Yep,
Oops,
you are
okay.
live. Now you're live. Yep.
Fabulous. We will call this meeting of the Akron Civil Rights Commission to order, it having been duly noticed, and we are present and ready to go. First thing up is we have approval of the March minutes. Those were distributed by email in advance. I'm going to see if I can just share that with you so that we're, here we go. So that we're looking at the same thing. And I'm just going to sort of scroll through this. So if you haven't already reviewed this, you can refresh your memory. And it wasn't a long meeting. And if there are there any corrections or comments on the minutes? Let's stop sharing that. Is there a motion to approve the minutes?
So
I
moved.
move that
Nancy
we-
Holland.
I
there-
second, Gina Kay.
Fabulous. Any further discussion? All in favor say aye.
Aye.
Okay. Any opposed? The minutes are approved. And we have old business. The investigation on complaint 19 ACRC 00013. We discussed this last time. We felt like we wanted to review the written report in order to be able to make a decision. I will just refresh your memory that the our task at this point in the process, right? A complaint was made, the decision was made to go forward with the investigation. The investigation was delayed for some time, but the report came in at our last meeting. Our task is, upon receiving a report, is to make a decision about whether or not there is reasonable cause, is that the language there? That to find that discrimination has taken place. And so that's the immediate decision for us. If we decide that there has not, we can dismiss and there's nothing further. If we decide that there is, then we go into a conciliation process where we try to have the parties work out some kind of an agreement. And then if there's no conciliation, we go and have a hearing and hold a hearing and make a decision. So what's your pleasure? Any discussion on what we do about this complaint? We do have a recommendation. I think the recommendation was from the investigator was that there not be a finding of reasonable cause. That I think I have that right. I will tell you that I do not have a pre-organized concept of how this is going to go. So if you're waiting for that to be spelled out for you, it is not going to come from me.
Chair, if I may.
Yes, please.
I recall from our, I'm looking at my notes from last meeting, and I know that where I left it, I still thought there was a question in my mind regarding the workplace inconsistencies in application of policies. And that although, and that I don't know the extent to which that contributed to the complainant feeling that he had experienced disparate treatment, harassment, and discrimination, but that am struggling with having an all or nothing proposition. If there is a sentiment that, along with the recommendation, that there was not discriminatory actions, I am left with the situation that can be repeated of inconsistent application of policies. The report, as I recall, detailed that others were, the refueling, I'm saying it wrong, but they go to the break and they go to the washroom, and that wearing shorts, other people were, similarly attired. And I think the issue with some forms of harassment is that it can go, and theoretically, not saying impugning the employer or any other parties, that it can be repeated without remedy. And so those things contribute to the workplace being perceived as unfair, and actually it is unfair. So I would like, if we could talk about that, if anyone shares that, because the uneven application of standards to employees, I think, is something that that is within our purview to address. So I just wanted to put that out there.
Esther,
Yes,
I completely agree. I also feel that this is an area that we can do a great deal of good, because in cases alleging disparate treatment brought in courts, there is a rush to, dispositive motions, frankly. And there's not, in my humble opinion, usually adequate time to tease out this idea that there are some who are engaging in the claimed offensive behavior or violative behavior who get away with it. And I do think that one of the services that this commission can provide is an examination of some of this micro stuff that perhaps would not be carefully examined in the court process. So I guess it begs the question, does that mean we actually engage in some examination of employees and supervisors? Does this mean more investigation? That's the question.
Commissioner Pitt.
If that is specific then to this complaint? Or
Not hearing you that well.
I wonder if, can you hear me better now?
Yes.
A little bit.
A little bit.
I don't know what would be causing that. My mic is, hold on. I don't know if that would be, specific to, is that specific then to this case? Or does that hinge on this case? Or is that an example of one of those times when we've spoken in the past about us initiating an investigation? Just a question.
So I'm thinking about a couple of things. One of them is on the question of whether this is a kind of an all or nothing decision point. Our finding today would be whether there's reasonable cause, right? Presumably that's not a finding that discrimination happened. That is a finding that there's reasonable cause to believe it, which is presumably a lower standard, right? And
more likely than not.
More likely than not, right? And then there's still a hearing, right? If we don't get conciliation, there's still a hearing where we would actually make a finding, right? If you think of those two standards as being exactly the same, I don't know why we would have two decision points. I think you have to think that this decision is a little bit not quite as definitive, right, as what would come after a hearing. And that, if what we're looking for is a way to have a conciliation process so that we can talk to them, get more information, encourage them to do some other things, and then we could all settle, then that has that result. Now, I'm not saying you should do that to get that result if you don't think that the standard has been met. But that is at least one way that this could go forward. Right.
Mr. Chairman,
Yes, Commissioner Maddox.
I would, I agree with Commissioner Thomas, Commissioner Holland. And I want to say that I'm not, in the interest of time, I'm probably not persuaded that we need further investigation. I think Commissioner Pitt's investigation and report has been extraordinarily thorough. But to proceed forward, I would just want to at least communicate to the organization that these micro inequities have been noted, that they are being put on notice. Because if to say that there's no, I guess, no probable cause, kind of lets them walk away unscathed and not even wrapped on the knuckles. So I'm just wondering if there are some administrative remedies that we could require, if not the conciliation, at least additional training brought to their attention, some of those things that were lifted out in the report, in the investigative report, so that, we don't just walk away. I don't know how much power we have to enforce that they do training and, bias training and other kinds of training. But I don't think we should just walk away. I don't know where we should go, but I just think that they should be put on notice that micro inequities were substantiated and the unfairness, that's been noted.
I would say that first of all, I agree with Commissioner Maddox, and I would say that procedurally, this would then have to begin with a determination by the commission that there is reasonable cause to believe that discrimination occurred, which if you're a visual person or a math person, I think can be illustrated this way, that it is at least 51% likely that discrimination occurred. That's the proof standard. More likely than not.
Commissioner Thomas, did you want to speak?
Yes, I agree with Commissioner Maddox, as well as noting Commissioner Holland's point. I'm struggling to go through the statute because can we not invite the parties to conciliation without a finding? That they can voluntarily at any point and John, you might be able to, because I'm looking and I can't find it, and I don't think I made it up, but
No, you didn't make that up.
Okay.
You didn't make that up. That's actually in Rule 16I. 16I does recognize that prior to making the finding of reasonable cause or no reasonable cause, the commission can authorize the investigator to facilitate what the rule refers to as a voluntary conference between the complainant and the respondent.
I'm looking in the wrong place.
To resolve the complaint in a fair, impartial, and respectful manner. So I think what the rule contemplates there is, getting the parties together and investigating the ability to resolve the matter with possibly some of the things that the commission has identified, possibly some training or some recognition of ways that business could be improved, so to speak. So that is a third option. That would need to occur before a finding of reasonable cause or no reasonable cause.
And
we just adopted that.
No, that's
Sorry.
been in existence. That's been in existence. I believe, but I can't tell you when. It might have been.
Oh, I can tell you. It probably
It might have been.
16.
I just know that we added it. I remember that we had that discussion about wanting to be able to do that. So I don't know when it was, but It was
Right,
not
right.
in the original rules. Yeah.
Hmm.
Well, if ever there was a situation where this would be useful, I think this is it.
And as
Go ahead.
point of
Yeah.
order, we have not, the commission has not formally voted on this. We held back last month to get the supplementary information. And because there were, we wanted that supplementary information, the written report that Commissioner Pitts provided. So, point of order.
Mhm.
Mhm.
So I have two thoughts about this. One of them is that I myself, in thinking through this case, there's the lawyers on this commission know there's a kind of a standard analysis that it's not always useful. It has been criticized that you go through when you have a discrimination case, where you start with, right, whether you have a Black employee who is treated differently than a white employee, and then the employer is required to give a reason why that difference, like treatment, occurred, and then we get to look at evidence about whether the employer's reason that they gave is a good one, right?
Mhm.
And I think we have all those elements here, right? We have somebody who has been let go. We have the employer saying, well, this is why, because of the infractions on the rules. And we have some challenge to that reason being given, right? Which is not clear that that has been evenly enforced or consistently enforced. So I do think that there's a path to a finding that there is a reasonable cause to believe that discrimination occurred. I'm not saying we need to do that right now. I'm just saying I don't think that it's out of the question to do that. The other point I wanted to raise is that if we decide to go forward on this sort of pre-finding conciliation or conference, let's not call it a conciliation, it mentions that it's an investigator. And it strikes me that I'm not sure whether at this point, if Commissioner Pitt, if you think it would be sort of more useful or less useful for you to continue to be in that role. I can sort of see it going either way. You're already familiar with the parties. On the other hand, it's sometimes helpful for the conciliator person to be someone else, right? Who they don't already have preconceptions about. So if you have ideas about that.
I do. I am of the
Yeah.
opinion in this particular instance, even listening to the flow of our conversation last time and today, that really there's a little bit of a knife edge here in the conversation that we're trying to weed out where that line is. And that in this instance, I think often our commission is benefited by those without the legal experience, but I think in this instance, we are actually benefited by one of the commissioners who has a legal background, because I know that I wouldn't feel adept at handling that exact knife edge. I would be happy to be a second in the space, knowing that I know the case, and to be a support, having done the investigation. But I would be of the opinion that another commissioner should step in at this point for the conciliation. And that would be my recommendation at any rate.
Mhm.
Yeah.
And I think what we'd have to keep in mind too is that if this effort, this conference, were not productive in terms of reaching a global resolution, that we would need to be mindful of the need to have adequate staffing for a hearing as well. So, big picture here. There are moments where I think that our commission could be larger, personnel wise.
I think at the moment, fully stocked, we are large enough to handle a hearing with another commissioner taking on the conciliation and myself being excluded at that point. I think we are.
Okay. Because
You know,
you don't want, for lack of a better term for this, a mediator, a conference mediator to be the same person as
Right, the
a
investigator.
conciliator manager or a hearing official or prosecutor, again, for lack of, better terms. These need to be different people unless someone sees it differently.
No, I think you're right, Ms. Holland. Any investigator or member that takes part in the investigation process would not be able to serve as a hearing officer. But I will point out that the commission's rules state that 3 members of this body will serve on the hearing panel. So you have 7. If another member besides Commissioner Pitt takes over, you'd be down to 5, but you'd still be able to meet your 3
Okay.
requirement for the hearing.
so there is a possibility that you would have the investigator, the pre-finding mediator, the post-finding conciliator, and then still need 3 more for the hearing, right? I mean, I think we still have that, but I'm just playing it out so that we all understand what's going on.
Right.
And I wanted to respond to a question that arose earlier. I think it's pretty clear that we can tell them anything we want. We can send them like suggestions, but that the power to enforce a remedy, I can't see that being our power until we have a hearing and a ruling. I don't think that we can tell them to do things. I mean, we can of course try to get them to agree to it. Does anybody have a different understanding than that?
No, I absolutely agree, Chairman. And I would go one further and say that we're that much removed from that if we go forward with the conference without a cause determination. I'm not trying to be, an aggressive, prosecutor here, but I guess I want us to be kind of mindful that we either see something here or we don't.
I suppose for me, my only question about that goes back to my question earlier, which is that I suppose I'm unclear on what point at which the testimony of other witnesses in an investigation can become a part of the complaint itself to some extent, because for me as the investigator, the scope of this complaint became limited to the complaint. That's why I asked the question about whether the purview of this complaint matches the concern we have regarding the respondent's responsibility to fair practice, and whether that another complaint undertaken by the commission using multiple and if not more people as witnesses might not give the scope that we're looking for if that is our concern. Because when it comes down to it, when you're trying, that's why if you read my finding in the report, I wrote it intentionally. I could not conclude that reasonable cause exists to believe that the respondent engaged in discriminatory process through the actions of its agents in this case. And I think there is nuance there. If we are looking, because of the testimony I heard from other witnesses, not necessarily just the complainant. So I think we've got to look at what the concern is that this has delivered to the commission, and then whether that is served within this complaint, or whether that concern about discriminatory practice is actually a broader concern affecting multiple people.
It's my understanding that witness, although they may not have been sworn, but that the witness testimony is valid because it substantiates those nuances. So if I don't know what would happen in a hearing or a conciliation, would they be sworn, to
No,
repeat
they
that?
would not.
So,
Yeah.
yeah,
It's
My-
really a voluntary procedure to try and, reach a resolution. Nothing that's said in that process would become evidence before this commission.
And remember that the concern of this complaint is about the firing of one employee. And there are multiple reasons behind that. There was a process to that. So that's the pencil point on this. So if you want to draw the circle differently, then the concern could be different. But there's a particular circle around this particular complaint.
Hmm.
So I don't want to, cut off debate. I think that where we are procedurally, right, the report has been given. We, at this point, either somebody makes a motion that we proceed according to Rule 16I to approve that an investigator be assigned prior to a finding. And that investigator will facilitate a conference if and it's voluntary. So if they say no, then we have an immediate next step, right? Or absent the motion, then we would go forward on a vote on whether there's reasonable cause. So what's your druthers?
At this time, I would move that we go forward with the 16I investigative conference with the respondents.
Commissioner Thomas seconds.
So any discussion about that? I think that my understanding is that we have heard from Commissioner Pitt that this would be a different investigator, right, than the one who did the initial investigation. And so that'll be our next decision if this motion passes. Other discussion about this motion? I'm just reading through the rule myself to make sure I understand this. May facilitate a voluntary conference between the complainant and respondent to resolve the complaint in a fair, impartial, and respectful manner. The resolution shall be conducted pursuant to the rules for conciliation. So we already have a conciliation process. Okay.
Okay.
John, does Commissioner Pitt vote on this?
I don't believe so. I don't believe
So I
so.
will abstain if you call. We'd minute my abstention, I believe.
Is there further discussion or any questions? All right, we have a motion. It's been seconded. The motion is to proceed according to Rule 16I to attempt to facilitate a voluntary conference prior to a finding of reasonable cause. All in favor say aye.
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 aye,
All opposed say no. Any abstentions?
Aye.
And the motion carries. We have, and so the next task actually is to assign an investigator to conduct that conference. This is the first one, so it's nobody's turn. If there is somebody who would like to step up and take this on, I'll entertain volunteers. Otherwise, otherwise after the meeting, I'll throw a dice or something and assign somebody.
Can
Or
we
you can let me
nominate
know.
people?
If
No
so,
nomination.
I'd like to nominate Commissioner.
I'm sorry, I didn't hear you. My audio went out.
Oh, okay. This is how I'll volunteer. Or please, you can put my name on one of those die.
Okay. And if anybody else wants to do that, if you let me know, kind of immediately after the meeting, I'll wait, a short time, and then I'll send that out by email. I think, is that all right, John? We don't have to do that right here at this meeting, do we?
No, I don't believe so. But I would probably need to know soon, because the rules say that, well, I believe, I'm not sure it says it in the rules, but what I contemplate needs to happen is the parties need to understand what the commission did tonight. So I anticipate drafting a letter to each of the parties, of course, share that with you. But basically what it would say is, commission has voted to provide the opportunity for a voluntary conference, and so will be conducting that conference. So be prepared to be contacted by that commissioner.
I only thought, yeah, it'll be soon. I only thought I would wait a discrete time after the meeting in case somebody wants to send me a message to say I absolutely do or absolutely don't want to do this. So I expect to send that tonight.
Okay, that'll be fine.
Just to note that I forwarded an email with an updated address for the complainant in this case.
Okay.
Okay.
All right, we have a resolution on that. And next item on our agenda is the report on investigation 20 ACRC 3 and 4. I have forgotten where we are on this. Commissioner Mobley.
No. Just to remind everyone where we last ended, I gave a report, and the recommendation of the commission was for me to go back and speak with not only the employer to get a copy of their handbook and a couple of other actionable items, also to speak with the complainant to see what it was that the complainant wanted out of this. The employer wanted to only speak through their legal team going forward. And I spoke with the legal team. I also spoke with the complainant. And this goes back to the question of reasonable cause versus what is actually being done. So what I can report out is that what the complainant wants in terms of monetary compensation does not fall under this commission, nor does it fall under the two companies where the complaint was lodged. So the complainant wants unemployment, and there's nothing that can really be done in that regard. The company itself has taken, according to their legal team, has taken the initiative to tighten up the reins, because to Commissioner Thomas's point in the last report out, there were some practices there that were a little loose. And so there's kind of things where this is the unspoken rule. They tightened up on some of their unspoken rules, along with the training for new hires and how to report anything that seems like harassment or discrimination. So they did that part, and are doing their part to ensure that all employees have a copy of the handbook and understand the processes and procedures, as well as their floor supervisors understanding the procedure in reporting any complaint that's presented to them. With those things in tow, I don't know how to give a recommendation. So I don't want to say, I'm with you, Nancy, or Commissioner Holland. I don't want to say that there's no finding, because there was negligence on the part of the floor supervisor who is no longer with the company. So I don't want to say that there's no finding. And I do want to acknowledge the company's efforts in regards to making sure that something like this doesn't occur again. But I don't know how to give the recommendation there if it's our job to say if there was reasonable cause for discrimination. Just because the discrimination came from the contractor and then there was negligence on the part of the floor supervisor. Commissioner Holland?
Yeah. You're muted.
You're muted.
You know, the number of Zooms that I do a day, you would think that I would be really good at this by now, and I am really not. So a couple of thoughts about this. I think that if we have enough here that you are analyzing the desired remedy on the part of the complainant, okay, then I think that maybe another way to look at this is whether the desire for unemployment is something that could be negotiated after a finding of reasonable cause. You're absolutely right. We have no authority over the Ohio Department of Jobs and Family Services. However, if what's been going on is that the complainant has been stiffed on unemployment because both of these employers are pointing at the other, or one or the other has opposed the application for unemployment, that's negotiable. So I guess what I'd like to know is whether you think that the contractor's actions were known to the employer and that the employer looked the other way to such a degree that they essentially acted to approve that contractor's actions. That's what I'm interested in knowing. Do you think that the contractor's actions were so known or should have been known to the employer?
It depends on how you define the employer. So there were two things you mentioned there, and we'll get to the negotiation of the unemployment in a moment. But it depends on how you define the employer. If you define the employer as the floor supervisor or the boss, if you will, on site,
Mm-hmm.
the answer is yes. If you define the employer, as the HR portion who would handle such a complaint within the corporate structure, then the answer is no, because the floor supervisor failed to report above his head.
I think we've met the necessary knowledge, though. If we've got a floor supervisor who knew what was going on, I think we're there. You don't have to go to HR if a supervisor knows what the deal is. I think we can impugn knowledge to the employer.
You're saying the HR is a different company, is that right?
No. What I'm saying is in the corporate hierarchy of one company, the supervisors in the office are looking for reports from the supervisors in the field. The supervisor in the field was aware of language that was unbecoming and then failed to report. Now, that supervisor has since been let go. That supervisor is no longer with the company, and the person above the in-office supervisor did not know. They were unaware. So that's why that's where it gets sticky in defining that now.
So the supervisor in the field is the representative of the company.
Absolutely. We've got some 20-year-old US Supreme Court law that says the company's holding the bag on this. So
Yeah.
Agreed.
Yeah.
I agree with that. I do. And so yes, so if that's where the line is drawn in the sand, then yes, I would deliver a report. I would deliver a recommendation for a reasonable cause. But however, I realize that the next step then is the hearing or what is the word? The
The
Conciliation?
conciliation.
conciliation, not a consultation, the conciliation process where we would recommend that the company does what the company is already doing. So I'm not sure where that falls. And to your point, in terms of the unemployment, she never filed. The complainant never filed because the complainant felt as if they would be denied.
But I don't think any of this affects whether or not we make a finding today. I mean,
Okay.
I think we receive
Yeah.
your recommendation. We don't think about the future yet. We receive your recommendation based on what has occurred. We make a finding, and we have yet to enter that conciliation. We have yet to walk that path.
Yeah.
Okay.
That doesn't affect the decision we make today.
Then it would definitely, if that is where the line is, and I appreciate the guidance of the commission because it's my first go round.
Yeah.
But if that is where the line is, then yes, I would recommend reasonable cause for discrimination.
Second,
I ask, I just need to make sure you know what you're voting on. Just because if I recall, there were two different companies involved here. And so just for clarification, which company did the supervisor work for that you're about to, make a motion for a finding of reasonable cause?
So it's just such a sticky one. It was great from the first one. Both. If we're finding reasonable cause for discrimination, both companies are at fault because the contract security company had they were directly responsible for the language. Their employees were directly responsible for the language, and the company that contracted the security company had the supervisor that failed to report. So both of the companies would be responsible.
Okay.
And as I understand the job of the commission to be the voice for those who might not be able to be the voice for themselves, the complainant needs a voice.
I would offer a motion that the commission makes a finding of probable cause in this complaint, in this case.
I would second Commissioner Maddox.
Okay. I think just to be clear, I know that we have gone back and forth in discussion, but our standard, I think, is reasonable cause to believe that discrimination occurred. Further discussion. Understanding that the next step will be to assign somebody to act as a conciliator, and then we would have to talk about what there is to conciliate. But I think that, I don't know that the commission has to discuss that further. The person who gets assigned to conciliate can sort that out with the parties. That seems to me. All right, but that doesn't even actually go to the question that's in front of us. There doesn't sound like there's any further discussion. All in favor of the motion to make a finding of reasonable cause that discrimination occurred, please say aye.
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 Any opposed? Any abstentions?
Aye.
All right, so the motion carries. We have made a finding of reasonable cause to believe that their discrimination occurred. So at this point, we are, what happened to my rules? I had them up here and then they went away. We assign a commissioner to go through the conciliation process that is laid out in Rule 17. We have only had one conciliation so far, which was, I think, Commissioner Christman. So I don't think anybody here has done a conciliation. We are again in this situation. And again, I will just pick somebody at random, or if somebody wants to volunteer to do this, if you let me know sort of shortly after the end of the meeting, I will accommodate any requests that aren't conflicting. Any other thoughts or suggestions or volunteers? All right. We are on to new business. We have a new complaint, which I believe was distributed by email. Let me see if I can pull it up myself. Oh, here it is.
Oh.
I will. You guys, you got it already, but I will go ahead and share my screen anyway to put it in front of us. This is Paul Mack Jr. versus Judge Amy Jones. Also naming as defendants Stacy McGowan, Oriana House, and the assistant prosecutor. John, have you looked at this for? I know that there are going to be people here that we can't act.
We did look. I looked at this, and Yamini looked at this too. And unfortunately, she couldn't be here tonight. But we did talk about that. We question whether this even falls within the commission's jurisdiction, because what he's really complaining about, it appears to be, he's complaining about his sentence, and he doesn't like the fact that he's at Oriana House. I would contend that you know that's outside the commission's purview, because it doesn't have to do with employment or housing or public accommodation. I don't believe being sentenced or being housed pre-sentence, whatever the case may be here, it is one of those things. Also, you know, a political subdivision is exempted from the types of bodies that the commission can exert control over. So I believe when he names the judge, he's actually, you know, naming the common pleas court, which is a political subdivision. Or if it's Oriana House and that's a jail facility, so to speak, I think that may be a political subdivision. So I really, Yamini and I had considered possibly sending a form and say, complete this form, because, you know, this is the form we use. But when you get down to it, if none of the things he's complaining about are within the body's jurisdiction, it just doesn't make sense to ask him to complete another form. So we really question the jurisdiction of the body, this commission, over the things that this person is complaining about.
Huh.
I mean, he at one point in the letter to you, Mr. Chairman, he demands that you get him out of Oriana House, and I just don't believe the commission can do that.
So if you scroll all the way to the top of the document, it really looks as though he got hold of a form for United States District Court. I mean, he thinks he's filing a post-conviction something. You know, he obviously thinks that he's filing a habeas petition or something like that? I think he's
So,
confused,
yeah.
and I think a kind and informative letter should go to him, explaining that this is not within our purview, and suggesting if there is some other resource, and or referring him back to his counsel, who I think he names somewhere in here.
Yes, he did.
So presumably we would construe liberally our pleading requirements, right? With like the fact. So what I'm looking for is whether in this document there is the content that, if they used our form, right, would constitute something that we could even have jurisdiction over, right? And so, and I think I agree that the judge certainly, I don't think, right, that we can consider a complaint against the judge. Oriana House is probably is private, isn't it? But I see where John and Yamini were going, where they're not the employer, they're not. Is it housing?
I don't think it's housing.
I don't think so either. A place of incarceration.
I don't think
Yeah.
incarcerated qualifies as housing.
Commissioner or Chair, you
Mhm.
know, I remember when I read this, certainly I think he wants to appeal that he's having HIV, even though a low viral load, wanted to be under house arrest, and that there's, that being housed in that facility is an endangerment to his health based on his condition. And so I struggled with that as well, trying to determine how it would fit in, and I was not successful in finding a way that it would. But then that's why we have these meetings, so that others can enlighten.
It really goes to his sentencing.
Yeah.
And that's not.
Commissioner, sir, Oriana House is a substance abuse treatment house.
Thank you.
You're welcome.
Mr. Chair,
Mhm.
is it,
Yes, Commissioner Maddox.
and also to John York, I'm wondering if, based on his complaint and his concern, if this might, if he has legal counsel, but this might be something that might be bounced back to legal aid, and his, given his health concerns. I'm just wondering if there might be a different place he can go to appeal his health concerns. And I am aware that just recently, Summa Hospital and Legal Aid here in Akron have teamed up to help people address things that could be impacting them from a legal standpoint and a health standpoint. So there might be some redress there.
I would be surprised if this was something that legal aid could take on.
As would I. This is really about a criminal sentence and seeking modification.
Mm-hmm.
So is there a motion to, I don't know, John, what's our verb for, we are going to deem this complaint not within our jurisdiction to consider?
Yeah, you would, and historically, when it, like, for instance, if something's happened outside the city, you found that it was beyond your jurisdiction, and then you would dismiss the complaint.
And then a letter would be sent to him explaining that the disposition.
Yes. And if I am correct,
yeah.
It sounds like if the commission decides to do that, it sounds like you also want me to copy his attorney on that letter.
That's correct.
Okay. Got it.
And we have talked before about, sometimes our letters are sort of the legally conservative minimum language. And that there was a suggestion here that this letter might be more hospitable, right?
Kind.
Gently, right? So, you'll draft something and we will get an opportunity to take a look at that before it gets sent, but you have to watch your email and review, because sometimes you want to get the mail out. All right, this is so if there's no further discussion on the substance of this, I'm sorry, did we get a motion? No, I asked if there would be one.
I will make a motion.
Thank you, Commissioner.
Second by Commissioner Thomas.
And that motion is to deem this complaint beyond our jurisdiction as defined by our ordinance. Any further discussion? All in favor say aye.
Aye.
Aye. Any opposed? Any abstentions? The motion carries. Right. Sometimes you need a motion to just keep you from rambling on and on and on. Let's see, where's my agenda here? We are eating into our time. Discussion of proposed amendment to the anti-discrimination ordinance. So you will recall that at one point in the past, the Fair Housing Contact Service came to us and talked to us about a concept for an ordinance having to do with housing, which was about source of income discrimination. Right? The idea here being that landlords currently, many of them say, we will not even consider Section 8 vouchers. Some of them have even said, we don't want the money that the CARES Act is providing through the United Way that will come directly to the landlord. We don't want to take that payment. Right? And so at the time that that was presented to us, there was no specific language for us to consider. And so we kind of approved in concept that we thought that that was a concept that we would support. Yesterday at the City Council Housing Committee meeting, there were two resolutions submitted having to do with housing. One of them was specific language on the source of income. I sent that out by email just before this meeting started. So that was not provided with very much notice at all. But I can bring it up, I think. And so I was invited at kind of the last minute to go to appear at that meeting. I was careful to specify that the commission had not approved that we supported the resolution, but I did give the history that we had supported the concept when it was presented to us. And I spoke on my own behalf that I thought it would be effective and useful. So here's the, wait, I gotta stop sharing the other thing and then share this thing. Let's see, wait a minute. There it is. So this is a document that says Housing and Neighborhood Assistant at the top of it. There's some history here about the number of people that use housing vouchers, the fact that other cities in Ohio have adopted this kind of protection. And then the substance of this is simply to add to our implementing ordinance, source of income as one of the categories on which you cannot discriminate.
Mm.
So you see here, the definition of discrimination, right, would, if this is adopted, would include source of income as a category. And then there's a definition of source of income, right? Any lawful source of money, including but not limited to wage income, public or private sources, court-ordered payments, benefits, right? This is a very broad definition of payment. And the concept here is that the landlord should not care where the money is coming from. If the tenant can come up, tenant or somebody on their behalf can come up with the money for the rent. I understand that I did not share this with you with very much time. So if you would like to take more time to think about this, I do think that what is being asked of us is that we formally support it. I think that is especially relevant to us since it's the ordinance that we are in charge of implementing. And then they would be able to represent, right, that that we support that. It's not gonna be a huge weight on the scales, I don't think, one way or the other. But this is one that they're not expecting to just pass. Like, it didn't go to City Council yesterday. They're gonna go through the 2 or 3 weeks. There may be, at yesterday's meeting, there were a couple of groups sort of speaking in favor, the mayor's office and fair housing. And I think that there will be some landlords who now will have wind of this, who will come and speak to City Council in the weeks to come. So that's the context for where our endorsement would fall. Is there questions or discussion? Commissioner Holland.
I am so pleased that this is actually happening. This may be the single most important addition to housing policy in recent memory. And I've been part of fair housing law enforcement for most of my career. This is true intersectionality. This is about really getting down to it with racism and sexism that's baked into the system. I am thrilled about this and would really urgently call for us to get behind this and be really enthusiastic about this. This offers such needed help for single parents. This is life-changing for a lot of people. And I would expect that there will be a very aggressive pushback from the silent landlord contingency, the very same group that, charges top dollar and puts very little into, and now I'm letting my personal politics hang out all over the place here, but we have a real crisis, not just in our sweet city, which I love so much, but throughout this country, where people are spending a ridiculous proportion of their income from any source on housing that in many cases is not just substandard, but it's unsafe. This is a real access route to meaningful parity in everything. It starts with your home. There's no more fundamental civil right than, the right to have a safe, reasonable, affordable place to live, without regard to your status as someone who receives, stimulus money or help from your parents or child support. I would urge the commission to get behind this and do it now. Thank you.
Thank you.
The most effective way for us to do that?
I hadn't thought of anything beyond a motion, but we could certainly talk about some other ways. I will give you a little bit of background that in the course of drawing this up and supporting it, right, some research has been done, right? HUD did a study a few years ago showing that the number of people who were turned down because they had a voucher in cities that did not have this protection, right? 70 and 80% of tenants, applicants were refused. And a couple of cities that did have some kind of protection like this, those numbers were like in 20s and 30s, like still being rejected, which is like, how does that happen exactly? But much reduced, right? We all know that when there's an ordinance passed that prohibits discrimination, that doesn't immediately mean, of course, right, that the discrimination stops happening. And also, there's one aspect that may not be obvious. You know, what those vouchers allow is for you to leave the neighborhood, right? It allows you to move into other neighborhoods if that's your desire, right? If that's your way to get to some place where there might be more opportunity. So this is one of the ways that people get stuck. With that, I guess we should just on the question about whether we endorse this as a commission. I think that's a simple motion and a vote. And then if there's sort of anything beyond that that we want to sort of some way to act, do we want to write a statement? Do we want to send people to appear at that next week's hearing? You know, those are all things that we can do and talk about once we decide that we're gonna, if we're gonna endorse it. And I do want to let you know, I'm not hiding the ball. There was another resolution that was introduced that I will tell you about after this one. That one has to do with allowing tenants to, if you show up with the money sometime before the eviction is complete, that you can stay, right? Not totally clear whether that one is a little bit less clearly under our purview, although I don't think that doesn't mean that we can take a stance on that, but we can talk about that after we are done with this one. Is there, I don't remember, I don't think that we already had a motion. Is there a motion
We did
to?
not.
I'd
So
like to make a
moved.
motion.
Second,
We have a motion and a second.
I think
Any-
Commissioner.
yeah. Any further discussion? Fabulous. All in favor, say aye.
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 Any opposed?
Aye.
Any abstentions? So the motion carries. In representing the commission's position to the city, I want to, if anyone does sort of go to a city council meeting or a committee meeting, we did not have a unanimous vote, so I want to be able to sort of accurately convey what the sense of the commission was. Commissioner Mobley, there's no requirement that you share that with us, but if you're willing.
I don't mind sharing at all. I have not, in fairness, I have not fully read, I've not been able to fully read the entire request. I've not been able to fully read it. However, I do understand let me choose my words wisely here. In theory, I completely agree with what the commission is saying. I completely agree with the fact that there are discriminatory practices in place based on source of income. I agree with this. However, I do not agree with forcing someone to choose where the money comes from. I do not agree with that. As a property owner myself, I do understand that sometimes what happens in theory versus what happens in reality are two different things. And while being sure that we are not engaging in discriminatory practices is very, very important, I also understand that as a property owner, ensuring that my property is safe and well maintained, and I am able to ensure that whatever tenant I have is willing and able to appropriately care for my property is important. And so I don't agree with forcing anyone to accept a Section 8 voucher. I do agree not discriminating against a person. I do, but I don't agree with enforcing where the money comes from. So I can't say you're a bad element because you have a Section 8 voucher. I don't agree with that, but I also don't agree that I should have to take a Section 8 voucher.
Thank you for sharing that with us.
Mhm.
I'm not sure what, so we have a motion that passed. And then we had some discussion, I think, about how exactly we want to communicate this or what steps we might want to take to.
And I think in my, Mr. Chair, in my impassioned support of this, full heart, empty mind, I think it's inappropriate for us to take an advocacy position on this ahead of the vote, absent a unanimous support. Just my 2 cents. I wholeheartedly support this, but I think if we don't have a unanimous commission vote in support, I think it's inappropriate. And I don't think that that's a bad position to take overall. We are to be a neutral body.
Other thoughts or comments on that?
Yeah, I believe that we would do well, and I'm sorry in some senses that we're in an online forum for this conversation. I believe that we would do well to actually delve into this more, because I think that Commissioner Mobley raises some very interesting questions implicit in the argument that she presented. And I think that as a commission, as a Civil Rights Commission, we would be in error if we did not continue to explore the ideas that she laid out, and laying herself bare as a property owner. But if we took it away from that example and we used it in a more general sense, I think that we need to explore that, because I think that it is complex, and we do need to be on the same page about what it means when we say that we don't want to allow discrimination, but we don't want to force people. Because if we go to other examples and we extrapolate that out, it becomes highly problematic. And I think we do need to discuss this as a commission further, whether we use it as an example about wedding cakes, or we use it as an example about Section 8 vouchers, whatever example we choose to use. As a commission, we do need to understand what we term discrimination, and how we understand all or any of the isms to operate within our society. So I think that I would almost ask for us to have a further conversation, even a meeting, and discuss these sorts of issues, because this is where the rubber hits the road. And then not necessarily even, we could re-vote, or we could re-look at this after we've discussed it further. That would be my suggestion at this juncture. Not to say that we have to be of one mind, but just to say that I think we've opened up a can, not of worms, but of possibility in conversation where the rubber hits the road, which is a wonderful place to talk.
I guess for the record, I'd just like to point out to the full commission that other jurisdictions within the state of Ohio have adopted this, and that it is now really kind of beyond argument that poverty or qualification for a federal assistance is very frequently a proxy for membership in other protected class categories. And I think we need to be mindful of that as well. I think, again, our position here, our duty is to be mindful of the whole picture.
Mm-hmm.
So just to share with you that the council members themselves were not of one mind on this, right?
can't imagine.
Councilman Neal represented as a property owner and landlord some concerns as well. And I think that where we are is, I mean, one of the things that's going on for us right now is that we are meeting once a month still, and these things are happening a little bit faster than that, right? I mean, I think ideally we would, and this is maybe something that I could have organized perhaps a little bit more adeptly, right? But ideally we would have had a presentation to us from the city once they came up with this draft, and then you know, been able to discuss some of these issues a little bit more thoroughly with people here to answer questions. I do know that it has come up that, you know, if you go into if you take a Section 8 voucher, you're required then to be in relationship with Akron, with the housing authority, right? And enter into a agreement with them, and because they're going to inspect to make sure that you meet the standards. Now, the standards themselves are not any higher than what the city is supposed to require. But it is nonetheless, no question, an administrative burden for the landlord. Although, right, the purpose is to provide someone without the means with housing. So I feel like we ideally would have more time to consider this and sort of take into account all of these considerations. I am not sure how I feel about the unanimity idea, right? I'm not sure why. I just have to think it through. I'm not sure why this would necessarily be any different than a vote that we take where, you know, generally the majority determines. But I do understand that if what we're doing is not acting, but endorsing, right, that might be different in a way that unanimity might matter. So I'm not clear on that part myself.
And if I could,
Mhm.
I don't, I'm with you, Chairman, that I don't know either way, but I understand that the majority vote would, if it were to be considered that would create the endorsement, I would still support the commission in the majority vote, although I opposed.
So as it stands, unless there's a motion to in some way withhold or withdraw the motion that we just voted on, you know, I don't mean to try to sort of procedure this into being, but just sort of as where we are right now, right, is that we had a motion and we voted on it. So which we adopted. So we have endorsed the resolution. If we want to not have that endorsement go out, I think there needs to be a motion for us to consider that motion to not have been done. I don't know, John, if there's a problem with with us saying that, or maybe to not communicate it in a particular way. So if anybody has a motion like that in mind, I think that we would entertain it. John, do you have any thoughts about whether there's, I mean, I don't think there's any taking back, and we're being recorded, right? I don't think there's any way to take it back that we had a motion and voted on it and that it passed.
Right, I mean, yeah, so procedurally where you are right now is that a majority of the body has voted to endorse the ordinance, but there's no prohibition against, for lack of a better term, reconsidering.
Right.
Or doing an amended motion, so to speak.
Right.
So if the body decided to move on such a motion, referencing the first motion, you didn't do anything improper.
Right.
Yes.
What's the will of the body?
I certainly do not want to change my stance, and I do not believe that the commission should stand any differently in terms of the possibility, the probability, the history, and the research on discrimination where housing is concerned. So I would not want to change my endorsement of this ordinance. I would want, and I don't believe a motion is necessary, but I'd be happy to make one if it is. I would want us to continue conversation regarding discrimination in housing amongst the commissioners so that we can hopefully achieve consensus and share ideas, really, is what I would want to have. I believe that the commission would be best served by that. And that is coming from the assumption not only of today's vote, but it's coming from my assumption that we don't all have to be on the same page about everything, but that conversation is helpful to explore ideas.
Well said.
And we lost, I don't know when we lost exactly. Gina K.
Gina K sent a chat to the group that she
Okay.
checked out at a quarter till, 5:45. So I believe she was part of the first vote.
Okay. All right. If there's no further motion on this, you know, John, I don't think the other resolution is on our has been noticed. So it's on our.
I wasn't
agenda.
aware. I mean, I put the agenda together last week and I wasn't even aware that that existed at the time.
Okay. I don't think we can, I mean, I think we can talk about it a little bit, but I
Yeah,
don't
you
think
could
that
probably
we can.
report, you know, what you observed at a public meeting, but I don't really think I don't think any deliberation would be proper or really even discussion. I think you could just report on it. And if it's something you'd want on the agenda for next month, I could do that.
Okay. I will report, you know, the city is doing a lot with regard to trying to address housing issues. There's pretty much a housing crisis going on. The news has been all over it. So one of the companion, and what they presented at the same time, they're really two different topics, is this pay to stay ordinance. And what it does is it creates a rebuttal, right, to an eviction. It creates an affirmative defense to an eviction, that if you are being evicted, prior to an eviction being filed, if you come up with the money, right, and then if the eviction goes forward, your defense would be, I offered the money, I had all the money. After the eviction has been filed, but before it's been determined, you can do the same thing by putting that money into escrow. And effectively, right, if it's a defense to the eviction, so if you come up with that money, then the eviction does not go forward. So that is what that ordinance is intended to do. It's not on our agenda. We can talk about it next time if we like. This one, I think, is a little bit less within, like, it is not specifically about discrimination, right? And so I think that it would be, I mean, it kind of depends on how activist you want to be, right? Whether to take a stance on a housing issue, or whether to sort of try to be more narrowly focused and say, you know, that is not about discrimination, and so we're not going to take a position on that. So we will put that on the agenda for next time. You know, in the meantime, you can, you know, consider whether you think that's something that we would do. I don't know where the city council may move forward before then. So, and of course, you know, any of you are, of course, welcome to go in your personal capacity to support anything you want. Right. So, any questions about that? Actually, or would that be deliberation? If I can clarify anything, yeah.
Well, thank you, Chair. You know, and as I read this in light of the other proposed legislation by the city, I couldn't help but think that, well, this does not prohibit the source of funds. Should someone be confronted with an eviction, those funds be presented at the last hour, and that pursuant to this, there's a this can be used once a year. And not to be cynical and looking at that, but I find that these are very interesting companion pieces of legislation that have appeared at the same time. Although one was probably not intended as a remedy for the other. Question. I could, is the commission, they're as commissioners, without speaking for the body, I might be able to make it to some meetings or things of that nature, because there's a useful intersection with poverty, housing, eviction, with my daytime job. And so there might be useful commission intersections that would be supportive to the commission, and provide opportunities for those commissioners who want to partake in that.
Some of you know that there's a racial equity task force that the city is undertaking, and there's a housing committee on that, which I'm on, and so there are a lot of sort of intersections in this work. All right, that is all.
I just want to say one more thing.
Yeah.
I appreciate very much that this will inevitably affect some pocketbooks, and that we're going to hear a loud bang and clatter. And I just feel really strongly that I need to say this, that poverty is expensive, and that this is the only way out is through. That unless and until we can really walk the talk, keep in mind that the Fair Housing Act, and not just 2 weeks or 2 years, but for a very long time, has included a provision in it that's about marital status, in an effort to get at, or familial status to be specific, to get at this issue of the money and where's the money coming from. And how do you get caught up when life happens? Because being poor is expensive. So I just kind of want to get that out on the table. I don't think I could sleep tonight if I didn't say that. So thanks.
Thank you. We have our next item on the agenda is the consideration of a semi-annual report. John, thanks so much for remembering that we have a semi-annual report twice a year.
Yeah, I have to apologize. I was a bit tardy because it was actually due April 1st. But I believe that if it gets tightened up tonight and I edit it based on what's happened tonight, I believe that it'll be considered timely.
And so this was distributed by email. John, is this an edited version of previous reports?
Yes, it is. Yes. So what I did is I built upon what you've already submitted to the mayor and council previously. But if something became irrelevant because it's over, I took that out. But like the history of the commission, I left that in because it talks about who the first commissioners were, and then it lists the present commissioners. So it sort of builds on itself. And I did the report of the actual cases similar to what we've done in the past. So I referenced that there were 2 existing matters on the commission's agenda that pre-existed 2021, and then I included that there was 1 new complaint filed in 2021, which was the one that the commission tonight decided to dismiss for lack of jurisdiction. So that's the type of thing that I go back and edit that before distributing it, and I could share it with each of you again once I edit it. I don't know that I'll be able to get to it tomorrow, but likely on Thursday or Friday.
I'm mindful of time. Does anybody have any particular notes that they want to or comments on the draft report that they want to relate to John at this time? And if you wanted to submit thoughts and suggestions by email after the meeting for a short time again, I think that'd be all right too. Commissioner Pitt.
I just say that I thought it was both concise and thorough and a job well done. Thank you.
Josh, should we vote on approving this report?
Yes, I mean, you should vote on approving the report, but I think that there needs to be recognition that I will need to make edits to, you know, things happened on at least 3 matters tonight, the 3 cases. And what I'll do is I'll read through it and see if there are other matters that need to be edited too as a result.
In which case I would move that we adopt the semi-annual review or report, assuming that we give Mr. York permission to update according to the minutes from tonight's meeting.
Second.
Any further discussion? All in favor,
Mr.
say
Chair,
aye. Oh, yeah.
Mr. Chair, when I do get it finished up to where I feel it's ready, I'll email it to you. And then I'll ask you for just to approve that I could put your signature on it because we have your electronic signature. So that way you'll get to see it one more time, just to make sure you feel I've gotten it right.
Well, and then once it's approved, we can certainly send it to the rest of the commission as well.
Sure.
Right. Yeah. Okay. And then I'm mindful of time. We are at the end. We're a little past the end of our allotted time. We have some sort of ongoing discussion about communications and education updates. Are there any of these that we need to discuss tonight?
Chairman, I believe you need to take a vote on the last motion.
That's right.
Oh,
That's
I'm sorry.
That's a
Did we
good
not-
catch. I missed that myself. Sorry.
It's okay, it's late.
We had a motion to approve the report. Is that the one? All in favor, say aye.
Aye.
Aye. Any opposed? Any abstentions? All right, the report is approved. Thank you, Commissioner Pitt, for catching that. So on the projects to develop community involvement, community education efforts, there's a working group on the video and some discussion about photos.
I think we can report on that fairly quickly, Mr. Chairman.
Okay.
So we had a working group and Commissioner Holland is going to take on the duty, the responsibility of trying to edit the PSA so that it'll be a little tighter as far as information conveyed. And Nancy, of course, jump in if you want to add anything.
Sure, just so everybody knows, the intention here is to simply have the PowerPoint track the statute itself, its brief history, its origins, so that we are all, speaking from the same sheet of music in public information sessions, without anything that can be, construed as anything but deriving from our role and our capacity as a neutral commission. I hope to have something to circulate to all of you before the next meeting. Hopefully we have something ready to roll out in, what month is this? So maybe in May we have something ready to go. What is time?
And then I can report quickly on the photographs. There was some discussion about maybe getting headshots from each of the commissioners that we may be able to use to update the city's webpage. I believe I've gotten 3 of your photographs so far. And I believe that would be Dr. Rice, Chairman Lee, and Commissioner Thomas. Those are the 3 I believe I have. So if you others have headshots, feel free to send them to me because I could collect them and then at the next meeting we could look at them and say, is this good enough? Or if it's not good enough, we may be able to schedule the city's photographer. But I think we'd still need to do individual photos due to social distancing. So it may be something you just want to wait on a bit. But that's the report on that status. I'd let you know that I did speak to administrative staff at the mayor's office, and we are able to update the web page when we get to the point we're ready to do that. That was something that Ellen Nish had been doing, but she's on leave right now, so we can still make it happen whenever the time's right. And then the
John,
only
Thank
other thing, I would just want to report that there were no public comments at the law department this past month.
I had assumed that you would use the previous individual headshots that were taken of us. Do you have access to those?
No, I don't recall individual headshots being taken. I thought that that was just the group photos.
No, I believe they were individual. Unless I'm, Brant, were they not individual photos?
I'm afraid that I do not remember.
I'm gonna go look.
It's
I'll look in my
just-
email. Sorry, I say that and then I start to doubt myself. So I'll look, John, but that was my assumption.
Okay.
I apologize.
Well, yeah, and
I'll
if you
look.
find it and you can shoot it to me, that would be, you know, and if that's one that you're satisfied with, then that's one we could use. But there's still other members that I need to, you know, get something from.
All right, friends, I have another board meeting I am late for. Is there a motion to adjourn?
So moved.
Any
Second.
second?
Second.
All in favor, say aye.
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 Thanks,
Any
everyone.
opposed? This meeting is adjourned. Thank you all so much for your
Thank
service.
you. Good to see everybody.
Take care. Be safe.
Hey, John,